Okay, everybody, it looks like our audience is now in with us, and so we're going to go ahead and get started. Colossal audience with us today. I'm so thrilled to see so many people tuning in for our virtual Sibley Lecture, and I'm really delighted to welcome you all to what is the 118th Sibley Lecture here at UGA Law. And this is a lecture series that was established in 1964 by the Charles Loridans Foundation of Atlanta in tribute to the late John A. Sibley, who was a 1911 graduate of the law school. And this lecture series seeks to bring outstanding legal scholars to our community here. And we're privileged to have one such outstanding legal scholar here in Dr. Monica Bell, who's visiting us today. And Dr. Bell is an associate professor of law at Yale Law School and also an associate professor of sociology at Yale University. And her research and writing focus on issues of criminal justice, welfare law, housing, race in the law, qualitative research methods, and law and sociology. And today she's going to be talking with us about her essay, which is titled "The Case for Racism Response Funds, a Collective Response to Racist Acts." And I'll hand it over to her in a minute and then pose a question or two to kick things off. And then we're really hoping that there'll be some audience participation by submitting questions through Zoom to us so we can bring in more voices into this conversation. And Monica, I know that you love Athens and it's not too far from your hometown here, and we wish that we could welcome you here in person, but hopefully we'll find another way to get you down here in the future. But for now, we're just really grateful that you would join us here virtually. Welcome to UGA Law, and thank you so much for sharing your work with us today. I'll turn it over to you now.
Thank you so much for having me today. I want to thank all of you for being here with me on Zoom. I am so grateful first to Dean Bo Rutledge, who I had the privilege of meeting when I was on the job market several years ago, and whose work to support first-generation college graduates and first-generation professional students I deeply admire and appreciate. I would also like to thank various staff, especially Laura Pulliam and Nico Terry, as well as Alex Perry, Julian Cook, and of course, Thomas Kadri. It is a true honor to be here for the Sibley Lecture. Especially on today, Veterans Day, I want to extend a special note of gratitude to any service members who might be here with us today. I truly thank you for your service, for guarding our complicated and difficult nation. But of course, recognizing our veterans has to mean more than just acknowledging them on one day a year. So as we are gathered today, too many service members are unhoused, jobless, suffering, struggling with various health issues, with insufficient support from our government or from their communities. Service is strength, but it is also sacrifice, and it is difficult. So I hope that as we celebrate today, and at this moment of transition and hopeful renewal in our nation, we will recommit to honoring our veterans by returning the gift of care and protection to them, especially as lawyers and law students, by fighting for resources on their behalf, by representing them, by fighting against structures and policies that do little to display our apparent gratitude for their service and that leave them behind. But I also feel compelled, before we go any further, to directly acknowledge that we are brought together on Zoom because of the global pandemic, which is now reaching new records in hospitalization in a second wave. So I was supposed to give this lecture on April 15th of this year in person in Athens, and I was really looking forward to it. I was hoping to come down a bit early and visit my immediate family. As was mentioned, they live nearby in Anderson, South Carolina, which is just about a 90-minute drive from Athens. But as we all know, the universe sometimes makes different plans for us. On April 1st, my father died from COVID-19. I spent most of the next 7 months in my apartment learning how to connect with people on Zoom and supporting other friends and loved ones through their own tragedies in this pandemic. And of course, in late May and June, after the nation erupted in the wake of the violent deaths of Ahmaud Arbery, Breonna Taylor, and George Floyd, the work of healing myself and my loved ones had to evolve into thinking about concrete ways to heal our nation from the scourge of racism. So today I want to tell you a bit about a proposal I'm working through now in joint research with one of my students, Jordan Brewington. So first, I want to bore you a bit with a little bit of talk about racism as a cultural phenomenon, drawing a bit from cultural sociology. Next, I'm going to speak a bit about routine racist acts, particularly unprovoked police calls that often affect Black people. Third, I'm going to tell you a bit about my preliminary proposal, Racism Response Funds, as a way to deal with the inadequacy of our currently available responses to routine racist acts. And finally, I want to work through a few objections you might have, though I'm eager to engage in conversation about the proposal and Q&A. So I'm hoping that I won't take forever to get through all this. So first, what is racism? By racism, I don't just mean the types of violent acts that are caught on video. The deep harms of racism in this nation and beyond do not just come through these most observably brutal forms. It also includes what some people call, quote, microaggressions, but what I would call routine racist acts, that's the language I choose to use here, which are the daily symbolic and structural violence that accompanies occupying a racially marginalized position in society. So racism is a collective cultural phenomenon ground into our structures and institutions, but also our ideas. The tests of racism are often psychological. So think about tests like the infamous IAT, which you may have taken yourself, which evaluates the snap judgments people make about racialized bodies and faces and try to suss out implicit bias. But actually, racism's daily occurrences are sociological, not just psychological, not within brains. So in terms of cultural sociology, racist ideas are part of what a sociologist Ann Swidler has called a shared American cultural repertoire or toolkit. That means that if we think of American culture almost as a grab bag of different tools, scripts, and resources that people take from and use in everyday life, racism is one of those tools. Racist ideas are neither isolated within individual brains nor fixed unchangeably across everyone. Thus, claims such as everyone is racist or I am not a racist are sociologically inapt. The better way of understanding how racism operates is to say that in a society in which racism is part of our shared culture and legacy, everyone has the potential to engage in racist acts that stem from a racist culture. Even the person who is generally anti-racist may still at times use a strategy or script from this shared racist toolkit, thereby causing harm through racist actions, regardless of their usual stances against racism. For Black people, racist ideas create a smog of suspicion around us, a cloud full of psychological lassos that can at times be thrown, not capturing our joy fully, but of course sometimes inhibiting it. So here's an example from my own life, and I use it to transition to the next questions I hope to address in this talk, which are what are routine racist acts and what tools do we have to respond to them? So several years ago, when I was a law student at Yale, one of my neighbors called the police to report me for standing on my porch for too long. So as I struggled to enter my apartment, hands and arms weighted with bags of books and detritus after a long day away at school and at the library and with campus organizations, because I was in all of them, my neighbor must have decided that I was trying to pick the lock of my front door. So as the police floodlight shined into my squinted eyes, as I heard the officers explain in this polite but scripted monotone that there had been break-ins in the area, as I haltingly responded to their condescending, suspicion-laden questions, my chest fluttered with fear and with rage at them, at my neighbors, at the predominantly white and affluent neighborhood where I was living at the time, and at the entire segregated city. You know, I'm grateful and profoundly lucky that the episode stopped there. We all know of incidents like this that go a different way. And my neighbor probably thought she was doing the community a service by reporting my suspicious behavior, my so-called suspicious behavior. Would my behavior this standing on the porch for too long with a lot of things in my arms. These mundane movements of a law student who's carrying too many books, which I'm sure many of you experience on a routine basis. Would those behaviors have been understood as suspicious if I did not appear to be Black? Almost certainly not. I think we know the answer to that question. So I, of course, thought back on this incident when the Cooper incident took place this May in New York's Central Park on the very same day that Derek Chauvin slaughtered George Floyd on a Minneapolis sidewalk. So by the Cooper incident, I mean Amy Cooper threatening to call the police on Black birdwatcher Christian Cooper. I'm sure most of you remember the incident well, but just in case you don't, just to make sure we're all on the same page, here's a quick rundown. So on the early morning of May 25th, 2020, Christian Cooper was in the Ramble, a relatively wild portion of Central Park, on his usual birdwatching routine. Amy Cooper, a white woman, was out on a walk with her adopted dog. Amy's dog was unleashed. Unleashed dogs are not allowed in the area, in part because it scares away birds. So Christian initially asked Amy to leash her dog, and she refused. Apparently, this was a frequent occurrence in the Ramble, so Christian came prepared to deal with these situations. He told her, quote, "Look, if you're going to do what you want, I'm going to do what I want, but you're not going to like it." And he pulled out a dog treat to lure Amy's dog away, hoping to incentivize her to put her dog on a leash. Amy, as we probably all remember, reacted very poorly to this. She escalated the situation, moving toward Christian and threatening to, quote, "call the cops" and, quote, "tell them there's an African-American man threatening my life." In a shockingly explicit way, she invoked what she already knew about structural racism and policing. She knew that if she, a white woman, uttered those words to police, they would hasten to protect her and would potentially threaten Christian's life. She hoped that by threatening to deploy police against him, he would know, as part of the script of being a Black man, to fall in line. Now, of course, it is hard to compare the Christian Cooper incident with the death of George Floyd. Derek Chauvin kneeling on George Floyd's neck for almost 9 minutes as Floyd cried out for his mother is the type of spectacular display of violence that shocks the conscience of even many who are rarely concerned with Black lives. Christian Cooper's story is more mundane. It could really happen to any Black person. As imperfect as they are, legal responses exist for the types of utter physical brutality that took George Floyd's life. Now, we of course see that those responses can be hard to actually implement in the real world. For example, I think many of us were reminded of the deep brokenness and failure of the criminal legal system when Breonna Taylor's killers went essentially unpunished. But even at an abstract level, there are few pathways toward legal recourse or healing for those who experience routine racist acts. It is well understood that constitutional and statutory anti-discrimination law are weak and basically non-existent forms of recourse for many problems that are racially inequitable, but certainly for most modern, systemic, covert, and quote, microaggressive or routine forms of racial discrimination. Various shortcomings plague workplace grievance processes for racial and sexual harassment, with concerns about retaliation and evidentiary issues, making it difficult to pursue recourse, even in blatant, egregious, and persistent cases of harassment. University disciplinary proceedings for racial harassment, concerned primarily with liability and not repair, sometimes run into insurmountable concerns about the chilling of speech and expression. Theoretically, other legal options abound, so tort suits for intentional infliction of emotional distress, Section 1983 civil rights suits, and more. But none of those avenues of recourse would address really routine racist acts against individuals. Other reparative policy responses, like truth and reconciliation commissions, offer more flexibility with respect to determinations of liability. They're not really about liability, they're more about repair. But they're usually designed to address specific moments or perpetrators of racialized or ethnic terror, not routine incidents. So if the mundane incident was caught on tape, which it rarely is because they're routine, the best we have really is internet justice. So the cycle of internet justice is as follows. First, a video of a routine racist incident is posted, often on Twitter, Facebook, or Instagram. Maybe one day TikTok will get into it, but I haven't seen many incidents start there. An explosion of comments and shares begins. A crowdsourced search for the name, the employer, and other personal details about the perpetrator commences. A parallel crowdsourced examination of the victim for blameworthy details also begins. Then, depending on the results of those two explorations, a ritual of cancellation may ensue. And the harmed person gains attention for a short time, but otherwise returns to life as usual, bearing the scars of the incident with little healing to show for it. So internet justice and cancellation produce justified negative consequences for those who have engaged in racist behavior. However, this type of response to routine racism ultimately falls short. It is at best a stand-in for the inadequacy of other responses. It emphasizes individual blame and shame and detracts from shared collective accountability for these routine racist acts, which means it does not cohere with the basics of how racism works in the framework that I started with. So racism as a cultural phenomenon. It also does little to provide meaningful redress to those who have been harmed. So there has been some effort to create or ramp up enforcement of existing criminal sanctions for unjustified or frivolous police calls, like the one Amy Cooper made. So for example, Amy Cooper has recently been charged with falsely reporting an incident in the third degree, which is in New York, a class A misdemeanor, punishable with up to a year in jail, up to 3 years of probation, with possibilities of a fine up to $1,000. However, that response, similar to internet justice, punishes the caller, but it doesn't do anything for the called upon. In addition, solutions that resort to expanding the criminal law are, in my view, undesirable in a world where the substantive criminal law is already far too expansive in ways that tend to exact particular harm upon Black people and Black communities, and where criminal legal authority is overused. There's also been an effort, in contrast, to expand tort liability for routine racist acts that involve unjustified police calls. So for example, in 2019, the Oregon legislature passed a bill that allows victims of unjustified police calls to file small claims tort suits to recover up to $250. While the solution comes closer to redress by offering an alternative to shaming, it only works, first of all, if the victim is aware of the police caller's identity. More fundamentally, the solution fails to create collective community level accountability and change in a racist environment. Shaming so-called Karens, in my opinion, without proper context, could even reinforce the notion that particular white individuals bear greater responsibility for racism than our culture's ideologies and structures do. So now we've reached point 3, which is the proposal, racism response funds. What are those and what models do we have for them? So I propose that communities, either in collaboration with government or working privately, develop racism response funds as an alternative means of providing redress and restoration to individual victims of racist behavior. Communities in this way can accept accountability for the racism they allow to flourish by failing to disrupt it. Racism response funds can take many forms and could be administered or funded in many ways. So we could see logics for funding on the federal government, state government, local government, or even kind of similar to community bail funds, they could be funded and administered in communities as a form of either charitable redistribution or mutual aid. The right model is going to vary by context. And frankly, members of marginalized communities that are deeply affected by routine racism in local spaces should really be the determiners of the precise structure of the model in a particular place, in my opinion. However, the basic idea is that racism response funds would distribute monetary compensation and make services available. So for example, mental health resources and narrative sharing opportunities to victims of racist acts. While there are many features that would distinguish racism response funds from other accountability mechanisms, the most central is that the community is bearing responsibility here. So there is precedent for using commissions and funds to respond to harms to which litigation is an overly costly or inefficient means of seeking redress or making people whole. For example, every state, along with Puerto Rico, the Virgin Islands, the District of Columbia, has a crime victims compensation fund that supports victims and survivors of certain violent crimes, such as sexual assault, homicide, and intimate partner violence. Crime victim compensation boards can cover an array of expenses, including lost wages, mental health services, funeral expenses, and even moving expenses and housekeeping under certain circumstances. It could be reasonable, analogously, to imagine racism response funds offering a set amount for a particular sort of act, but for example, also covering the cost of therapy to cope with the stress of experiencing a racist act on that individual, but also for training or other types of opportunities for members of communities in a broader sense to avoid engaging in racist acts. So instead of prosecuting Amy Cooper, we would instead go to her neighborhood or something like that and have, these funds could be funding trainings or resources or carnivals or some sort of way that we have to kind of disrupt the continued ideas that perpetuate racist acts. Many crime victims compensation schemes, I should note, are funded by defendant paid fines and court fees, a process that has contributed to damaging and widespread penal debt. They may also impose other criteria and limitations on crime victim compensation that can make these programs accessible only to the most sympathetic seeming victims, and thus ultimately can be more regressive than restorative. So what I'm pointing out here is that racism response funds should not mirror most victims' compensation funds. For those reasons, I think they often function unjustly. However, the general design of responding to victims' physical, economic, and emotional injuries in multifaceted ways make the State Victims Compensations Fund a potentially attractive intellectual model for racism response funds, even if not a totally practical one. So perhaps the most famous Victims Compensation Fund is the September 11th Fund, which is structured quite differently from a Crime Victims Compensation Fund. Congress established the September 11th Fund less than 2 weeks after 9/11 and routed its funding through the US Treasury and its administration through the Department of Justice. In order to receive compensation, victims must provide evidence that they were present, but they can receive compensation for non-economic loss if they do not have evidence of the economic value of their losses. Some other victims' compensation funds follow a similar type of model, with special masters flexibly administering the funds and setting criteria for compensation. It's also possible for racism response funds to be incorporated into national police reforms along a model more like this, which these national police reforms are far more likely to gain traction in the new Biden administration than they were in this current administration. So for example, several police reform focused research centers at law schools have proposed establishing a federal police accreditation agency and perhaps appointing like policing czar, so some person who's within the Department of Justice, but who has flexibility, and that person would streamline federal police oversight. Given the close relationship between racist police calls and many of the tragedies that have illuminated the need for widespread police transformation. Perhaps one task for a federal entity or person like this would be overseeing a national racism response fund similar to a model that I talked about earlier, or I think more likely and more effectively providing technical support to local funds. An immediately implementable racism response fund, so one that would not require us to go through the bureaucratic rigmarole, could model itself after local community bail funds. So instead of routing the funds through a governmental body, communities themselves could come together to create a racism response fund that would offer victims of racist acts compensation for their losses and support for their recovery and flourishing. Now, community bail funds pool monetary resources to get people out of jail by making their bail, but they also usually have broader goals that often include radically transforming or even abolishing prisons and the criminal legal system. So this is another way to think about the capacity of the potential transformative capacity of racism response funds. It's not just about giving people money because they have experienced routine racist acts. It's also about transforming our places, our communities, and the way we think in response to routine racist acts. So of course, the comparison to bail funds is helpful, but it's not perfectly analogous. Unlike bail funds, no external actor is determining the dollar amount to disperse. Also, unlike bail funds, the support would not be mostly self-replenishing. So bail minus fees is returned to the community bail fund once the individual returns to court. So fundraising for a local community-led racism response fund would have to take this fundamental distinction into account. Yet, because there is no court setting large sums of cash bail in the first place, it is also likely that the fund's money could stretch farther depending on the amounts in the fund and the amount it pays out for each type of offense. Establishing a community or local government-run racism response fund could thus serve as both a practical intervention and also a way of expressing the community's recognition of collective complicity in perpetuating racism, segregation, and its accompanying ills. So these funds would be a public, concrete means of acknowledging the pervasiveness of racialized suspicion and also actively constructing accountability and healing both on an individual level and a collective level. In some places, community-based racism response funds might constitute something like mutual aid, given the routine nature of racism and the potential reciprocity of the support that would emerge over time. In other places, such as predominantly white and affluent communities, the structure and the logic might reflect commitments to redistribution or more fundamentally reparations. So finally, I want to turn to some obvious objections to this proposal. There are numerous potential objections. The most obvious concerns would focus on implementation. So given the routine nature of racist acts, how would the fund select which victims to compensate or support? Frankly, I'm punting on that question. And I'm punting on that question because of what I said earlier, which is actually communities should be negotiating over those types of details. What I'm trying to do here is start a conversation about how you could deal with these issues. And also, I think it serves as a swan call, or it helps us understand how pervasive racism is if our concern is administrability because there will be too many claims. And I think that is part of a reason to have funds is in fact because of the administrative difficulties, because of the routineness of the incidents. Of course, other concerns are more fundamental. For example, paying people for the racism they experience might promote the idea that racialized harm can be assigned a monetary value, that human dignity is a commodity that can be bought and perhaps sold on the private market. This argument might be thought of as a neoliberalism critique. This concern is especially robust in a nation with roots deeply intertwined with racialized property, the trade of Black people on the private market, the taking of indigenous land and resources through colonialism, the property value of whiteness, and more. However, one might understand monetary compensation from a racism response fund from a non-market perspective. So racism response funds can't make a victim of racism truly whole, no matter the amount that is paid, and racism response funds should not understand themselves as paying for individual restoration and dignity. Instead, racism response funds should be asking themselves this question: what amount should the community offer this victim for perpetuating the conditions under which this harm occurred? The dollar amount is not a means of purchasing forgiveness from the aggrieved. Instead, it is a way of concretely expressing responsibility for the harms of racism, and that accountability is what fosters repair. So critics might also object to compensating victims of racist acts because it will be difficult to clearly quantify the harms or to figure out exactly who should receive compensation. So one might call this type of objection a commensurability critique. This issue has long plagued punitive damages and damages for pain and suffering in tort law, and has also been one of the main arguments that critics of slavery reparations have offered. Usually it seems, in my opinion, to deflect from deeper ideological opposition to reparations. Yet, we assign dollar values to non-market objects frequently, with the aforementioned tort cases as one approach, as well as the complex and widely variant formula for local property tax assessment. Perhaps community-led and collective forms of evaluation that have been proposed in other contexts to ascertain the true value of property entitlements could be useful as a valuation mechanism in the process of establishing racism response funds. But here, I think just the conversation about compensation is the important move, and the precise dollar values are not going to be perfect. A third critique, and the final one I'm going to talk about right now, might focus on the scope of the proposal, and this is the critique, the main critique I have of my own proposal. So this recognizes that racism response funds are not a structural intervention into systemic racism. So this critique is correct. This proposal does not on its own provide a path to larger racial healing and justice, and racism response funds should not supplant structural changes that are necessary to untangle systemic racism. However, there are two aspects of this admittedly not fully structural idea that I think make it a valuable kind of interim step. So first, similar to bail funds, as I mentioned earlier, racism response funds can be a practical intervention while also providing space for deeper consciousness raising and organizing around broader racial justice aims. So to be part of a racism response fund, or to do that work, or to have one, is to be part of a much larger conversation about racial justice in America. Second, and relatedly, racism response funds demand a shifting of our analytic lens from punishing racists to responding to the effects of racism, and from individual condemnation to collective responsibility. Those shifts in framing, too, will be essential for effectively approaching more ambitious horizons of accountability for fundamental racial sins, such as reparations for slavery and settler colonialism. So that's the idea. I hope that in this time of transformation and with a renewed commitment to racial justice, that we will also transform our strategies and systems of accountability for racist acts. I look forward to further conversation, and sincerely thank you for listening and for having me be a part of this august lecture series. Thank you.
Great, thank you so much, Monica. That was wonderful. I want to just begin by offering my condolences for the loss of your father, and just recognize that, this pandemic obviously continues to have such a horrendous effect on communities around the world and in this country, and particularly within the Black community. And I'm just so sorry that you experienced that effect so directly in your family, and thank you for sharing with us today. We have over 120 people in the audience, which is no mean feat for a Zoom event held at the end of a very Zoom-filled semester. But they got a really great treat today in your lecture, and I want to bring them into the conversation. But I'll I'll kick things off with a question, and then I'll open it up. And while I'm asking and you're answering, I'd encourage folks in the audience to please post your questions in the chat so that we can turn to those. But so my question really is, in searching for this collective response to racist acts, you're obviously skeptical about internet justice and criminal and civil actions. And I'll admit that I share a lot of that skepticism. But I want to drill down on just a couple of things you've said as a way to maybe see exactly what we might gain from racism response funds that we don't have now. And so, you say that internet justice is this kind of intense but fleeting form of justice. It does little to help those who've been harmed, you say, because its reach is sort of narrow and it really focuses on individuals. And I love this line from the piece. You say it's a bad apple's reaction to racist harm that ignores the rotten trees, which is great imagery. But I'm wondering if that might undersell a little bit the power of internet facilitated social change. So even the examples that you give of Amy Cooper, sparked widespread conversation online and in sort of real space. And particularly when sort of paired with the police killing of George Floyd, which happened on the same day, right, catalyzed these protests across the country that were surely about much more than the individual incidents themselves. And so I'm wondering if, these moments of internet justice, while nominally about, or initially about bad apples, can actually also be about rotten trees. And similarly, my tort students who are in the audience, they might be disappointed or think that I've been misleading them all semester about the significance of tort law, because being about more than just the particular case that's before them. So we've talked about the expressive effect that law can have. Yes, to send messages about individual wrongs that are committed, but also to serve as a vehicle, in part for conversations about collective responsibility. I start my torts course with talking about Taylor Swift's battery case that she bought for only $1 in nominal damages against a radio show host who groped her, right? And Swift, when she wins, she says this was symbolically immeasurable to all women. And there's this great quote from a 10-year-old fan of Taylor Swift's who's saying that she wanted to tell Swift, thank you for standing up for me and for other women across the board, right? And so, you say that lawsuits and criminal prosecutions are concerned only with individual wrongdoers and can risk ignoring the shared culpability. And as I said, I don't challenge you on that, but I am wondering if you see any place for community level accountability through things like internet justice and lawsuits that maybe are initially or procedurally about individual wrongs, but that practically can be about much more. I'm kind of wanting to push you on that as a way to maybe talk about the difference that you see with racism response funds as well.
Thank you. I love those questions. Thank you. Those are really helpful. And of course, I appreciate the condolences. So on the questions, so I see first, internet justice and tort suits, of course, can have effects that are larger than the individual cases. So when I think about the effect of our well, I guess I'll say this, but there's also tension. There's tension between the individual culpability that emerges from internet justice and tort suits and the collective impact. So you may recall that at some point with Amy Cooper and the specific, everything being specifically directed at her, they reached a point where there was a sense that it had just been too much on her, right? Like, so it's like, oh, well, now she's been canceled, she's lost her job, she's lost her dog, and the conversation became about the perils of cancel culture instead of about this larger sort of accountability. So there's a way in which, of course, internet justice, I'm going to focus at each place at a time. Of course, there can be a potential effect of producing more community level change, but it's a fraught because of the major focus on individual accountability. And so I think there's a tension. But more than that, I see both of the examples you talk about as being incidental. So internet justice creating these larger conversations, and tort suits as, in particular the Taylor Swift example, which is a good one, as kind of showing, can be an example of people and creating other types of conversation. Those are incidental. Like, so their effects, of course, Taylor Swift's tort suit would not have had any sort of positive effect if Taylor Swift weren't Taylor Swift, first of all. So most people who would be dealing with routine racist acts aren't famous, and therefore there's no kind of so if you get the $250 when you go to small claims court, that doesn't produce any sort of collective response. I think it actually stands in the way of one, because there's, everyone's assuaged now because like the racist paid the $250, the racist individual. And then I think what's key about racism response funds, I just want to, I'll end here because I know there are questions, but I think this is a fantastic set of questions. What's key about racism response funds is that they set out to create collective accountability. It's not incidental. It's not kind of just like an effect. When Christian Cooper's sister posted that video on Twitter, she wasn't trying to, just like a conversation, but it's a conversation about how awful this person is, or how maybe it's even how awful white women are. I think that's often what people say, but even that type of conversation doesn't get to collective accountability. So anyway, that is what I'm trying to, that's a distinction I think between these models, but I do think, of course, the effects, I think you're totally right, I undersell the collective potential effects of some of the legal solutions that I lambast in the short version of the piece.
We'll look forward to you expanding upon that when you do expand the pieces. I know you're hoping to do, but thank you. Wonderful response. So I'm going to now bring in a question from one of my colleagues, Joe Miller, and he says, "Thank you, Dr. Bell. My question is, could it be that in at least some cases, a personal apology from the wrongdoer to the wrong could help both repersonalize the compensatory act and help demonstrate the propriety of compensation by evidencing the reality of the wrong?"
Yeah, so that's great. And I think that's true, right? And so I think it's certainly true that a personal apology can be healing. I think a personal apology can also, of course, it can kind of play that evidentiary role of establishing the need. So, and I want to be clear, I think this question makes me want to be a little clearer about the function of collective accountability. It's not to say that there's no individual accountability, right? So it's like they're operating together at the same time. And I should also, I guess I'll also mention one thing about apology. So I've actually studied apology a bit in the policing context. So I'm really interested in processes of reconciliation by police departments. And, you have these police chiefs who apologize to the Black community or whichever the specific affected community in their locality is for police racism. And one of the things that has been shown in that work, and so a lot of that work is done by David Kennedy and his National Network for Safe Communities organization. One of the things they show is that you can't, of course, just apologize. There have to be follow-up acts in order to make the apology have more effect. Otherwise, it's just words. And I think this applies in a smaller sense here in these individual acts. So one of the things that Racism Response Fund could do is provide the follow-up that an individual apology doesn't do. Because it doesn't really make sense to have an individual apologize for committing a racist act and then they individually try to do the work of rooting out the racism that caused their behavior, because they're not fully individually culpable for it. But anyway, that's a great question. Thank you.
Great, thank you. So I'm now going to bring in some student voices. A couple of my students have asked great questions, so I'll celebrate them here. First from Chi-Chi Drayton-Smith, and she asks, this proposal really hinges on the ideas that, one, communities are willing to take this idea seriously, two, that communities won't take this idea and turn it so that it poses either more harm than good or at best a neutral result, And 3, that communities won't place the burden on people of color to make this work. And she's curious if you have any sort of ways in mind to maybe combat some of these obstacles. And I'm going to pair this with another question from Anna Skarts, another student, and she asks whether you could maybe talk further about how you see these racism response funds as interacting with the broader idea and debate over reparations.
Great. Those are fantastic questions. Really impressive students. So I'll just take them in order. So first of all, I don't think the proposal turns on these aspects. So communities taking it seriously. I mean, I guess it does turn on that, right? I mean, the communities wouldn't adopt the proposal if they weren't going to take it seriously. Could pose more harm than good. I think that's actually entirely possible if they're administered poorly and placing burdens on people of color. I mean, you know, I think those of us who operate in predominantly white spaces recognize that if white people are taking up anti-racist acts or anti-racist projects, it almost always implicates in some additional work for people of color. But that being said, so part of the conceit of the idea is to say that communities on a local level actually have to work out some of these details because basically because of the disempowerment through which kind of proposals that come from on high or externally, kind of what their details are. And so essentially what I'm trying to do is put out the idea, recognizing actually that it certainly has the potential in many instances to cause more harm than good. And it also has the potential to just kind of, you know, be yet another kind of unfortunate, you know, effort at diversity that falls flat because of implementation problems. And so basically, I think I'm agreeing with you that these are problems, but I'm not agreeing with you that that makes the proposal bad. What I'm saying is that the political work that has to be a part of the movement, like this political work and movement work that's essential here. But I know that's an unsatisfying answer, and I'm happy like email me if you want to talk about it more. In terms of my handwriting is very bad. How do I see interacting over?
I think it was with reparations, the idea, the broader project of reparations.
Yeah, okay, so actually the I didn't really talk about this much in the lecture, although I mentioned it quite briefly. I see this, so I think my belief is that the only way reparations writ large is going to happen is through vehicles of reparations writ small. So my co-author on this paper is in the process of publishing a paper about localized reparations for the descendants of people whose families were enslaved on plantations that are used for tourism. It's a really fascinating proposal, and as part of my thinking, it's been really shaped by her work, Jordan Brewington. And the idea is just basically to expand the mechanisms through which we are engaged in reparative acts, with hoping to build more political capital and capacity and evidence about other forms of reparation. So for me, this project is a part of that broader effort, not a detraction from it.
Wonderful, thank you. So now a question from Russell Gabriel, another one of my colleagues here. And I should say he begins by saying, thank you, Dr. Bell, for one of the greatest Sibley lectures ever. So big response in the audience here. But anyway, so Russell says, it's a long question, so I'll paraphrase it a little bit, but he says, how do you accommodate historical harms in communities whose link to those harms, right, whose complicity in discrimination against particular groups is minimal to non-existent? So for instance, Georgia's history of harming African-American persons and Native American persons is obvious and apparent. But on the other hand, its participation in systemic discrimination against Asian Americans and perhaps Latinx Americans, right, might be considered tenuous, at least until recently, right? But if we look at California's history, it would be different to Georgia's, right? And so he says, one route might be to collapse individual groups into two categories, non-white and white, and there's some historical merit to that approach. But he also says that, perhaps collapsing racial identity into two categories misses so much, and perhaps the approach is simply not fault-based. And that's sort of his kind of provocation to you maybe to react to that set of issues.
That's great. So I have like an initial response, but it's not really, I'm not sure I'll agree with this shortly thereafter.
I hereby, as moderator, give you the right to recant at any moment when you decide you don't agree with what you've just said.
Yeah. So it is certainly true. And I think racism response funds could take into account, and probably should take into account, the specific localized and historical context of places, and how we think about these issues. But I guess part of me doesn't want to root racism response funds in historical context. And largely for some of the reasons that I think are implicit in the question. I don't want to get into, if you call the police on, one category of person who has a different, whose group has a different relationship to the place than another category of person. But it's all, but it's ultimately about, racial inequality or racial racism, that we would then give them different dollar amounts or something bizarre like that. I think that would be an unfortunate direction to move in. So what I prefer to do instead is operate a little bit more in terms of contemporary sociology. So if we think about the Cooper incident, of course, we know what Amy Cooper was invoking when she called the police in that moment, and what it reveals about our current politics, not all of the politics of the past, even though of course it falls in line. So I think you're right that I think a fault-based system hampers some of these broader conversations about historical context. But I also don't know that racism response funds needs to deal with all of that. And in fact, I think rethinking the relationship of racism response funds to fault altogether is probably what I'll want to do.
Great, thank you. So we have now another question from one of our students, and it actually dovetails with a question that I had, so I might just sort of pair them. And so Jack Mahan asks, is something like unconstitutional stop and frisk of racial minorities routine racism, or rather does the phrase relate solely to actors in non-official capacities? And this in part tied into something that I was maybe planning on asking you, which is I really enjoyed another piece that you wrote this summer, The Many Forms of Police Violence, where you talk about, how some of the actions that police engage in, right, is not only physical violence, but these broader ideas of structural and symbolic violence against Black and brown people. And so I'm wondering if you might draw some connections between the work that you've done that focuses more directly on police actions and then some of the more private individual focused stuff that we've talked more about today.
Yeah. I think as a way of getting to that question, I'll very briefly mention a piece I published this summer that I've written a long time before called Anti-Segregation Policing. And basically the baseline idea of the piece is to reveal that police reproduce segregation, residential segregation. And one of the kind of nagging issues and questions for me in that project is sure, police do that, but it's private individuals who are behind all of this, right? It's because white people want their areas to remain white unless they're gentrifiers. There's a whole other sort of conversation. But many white people want their areas to remain white, and that is why police are involved with reproducing these divisions. So I, in the space of unconstitutional stop and frisk, in the case of police violence, I think there are other types of levers we have or should have at getting at official racism by the state. But the thing that is just so troubling to me is that we cannot separate the state from the people. And this is like my way of trying to envision a strategy of dealing with the people, but also in their collectivity, not as individuals. So this is, but some of the solutions to deal with police activity, I think, are structural changes to police departments. So I mentioned the reconciliation earlier. That's not really a structural change, but it's a start of some cultural change at least. I'm a strong proponent of just having less policing, especially in Black and Brown communities where there is a lot of policing. People are unsatisfied with police response, but having more police doesn't seem to actually do anything positive in terms of people's experiences. So I'm like, I've been in favor of the defund the police movement. I'm also deeply in support of other Black Lives Matter initiatives. I've written in favor of shrinking the police footprint, and all of that is because of the inherent structural nature of police violence that runs alongside private racism.
Thank you. So I think in maybe our final question, although I personally could stay here all afternoon and chat about this, but one thing that I'm particularly curious about is the role of personal narrative. And you today used it and shared an experience that happened to you while you were a law student. You also in the piece talk a little bit about how racism response funds could in some sense create a vehicle for narrative sharing. And so I was wondering if you could maybe just say a little bit more about why you feel narrative is important in this area, what we gain by having more avenues for narrative.
Yeah. So I really view racism as, in many ways, a process of dehumanization, categorization and dehumanization. Racism keeps us from seeing the humanity in other people. And I mentioned George Floyd crying out for his mother when he was being slayed and slaughtered, because that's one of the things that people who don't have empathy with Black people in general or kind of Black Lives Matter initiatives, that's a thing they point to. It's like, yes, George Floyd has a mother who is devastated by this. And I view narrative sharing as a way of trying to incorporate humanization and lived experience into our legal and policy analyses. Is one of the things I'm most passionate about. I wrote my first paper that I ever wrote in law school was about voice scholarship, which I'm trying to do in different sorts of ways using sociological techniques. And I think that part of my ambition in terms of the Legal Academy is to contribute to the reintroduction of narrative into not just scholarship, but also into our policymaking. It's often really a part of our policymaking, but it's a part that people take less seriously. But I actually think it's at the core of everything we do.
Well, I couldn't agree more. And I think that's a inspiring note for us to end on here today. We did have some questions that unfortunately didn't have time to get to, but I'm going to see if we can record them somehow and send them to you, because we had some really wonderful audience participation. But I just want to end by thanking you again for being here today, for sharing your time and your wisdom and expertise with us. It's a real privilege to have had you here. And as I said, just to reiterate, we'll try and find some other excuse to get you back down to Athens at some point in the future. We'd love to welcome you properly here in person at UGA Law.
I'm always happy to come. Thank you. Thank you.
Wonderful. All right. Thank you, Monica. See you soon. And thank you to our wonderful audience as well.